You're listening to Leadership Powered by Common Sense with your host, Doug Thorpe. Here's Doug.
Well, hello again, everyone. This is Doug Thorpe, and you are listening to another episode of Leadership Powered by Common Sense. We're the show where we try to help you as a business owner or in a role of leadership somewhere in the business world, find better ways to do the things you've got to do and things you may not know about. And today, my guest is an expert in employment law. And I know this is a real keen area that, as we were talking in the green room, owners in particular of smaller businesses tend to trip into this and have very unhappy accidents that may, in fact, cost them greatly. And we want to talk about some of the basic things to think about to protect you from that sort of risk. His name is Alan Crone. He's out of the Memphis area. Alan, welcome to the show.
Well, thanks for having me, Doug. I appreciate it. To look forward to our conversation.
You bet. You bet. I always like to ask my guests to give us a little bit of backstory and kind of the journey that put you where you are, or how early in life did you decide this was the specialty area you wanted to get into?
Well, I'm going to date myself a little bit. My exposure to the legal profession was watching Perry Mason reruns. I'm not old enough to have watched it, the original airing, but I watched him in reruns. And I always liked the idea. I was a theater major for a couple of semesters, so I've always been drawn to the drama of the courtroom. And when it came time to put my political science degree to work, I decided that I needed a postgraduate degree, and I went to law school. And my intent was to become a trial lawyer. And that's really what I've become. And over the years, I've migrated towards employment law. I find it fascinating intellectually and factually. And it's really, really important. There are few areas of the law that aren't important, obviously. But you're in America, your relationship with what you do for a living is so a big part of who we are. And I always say what we do is who we are in America. And so when that relationship is ruffled, if you will, or threatened, it's a big deal. And it's important for employers to be fair and to see the employment laws not so much as a burden, but as good business. If you're complying with the employment laws, that's good business. It's good business not to discriminate, not to harass people, to pay people a living wage, what their value they're adding to your enterprise. So that's kind of how I got here. I can't say that I went to law school saying I want to do employment law, but over the course of the first 5 years of my practice, I ended up doing more and more employment law, and I really enjoy it.
When we think of this arena, obviously it's pretty huge, and I guess what I would like to frame, and you correct me if you disagree, but I've always looked at business law at two levels. There are clearly some federal statutes that are out there that do impact businesses somewhat, sometimes, depending on the law, regardless of how big you are. The idea, if you're going to write a paycheck to somebody, you become subject to those federal statutes in some areas. And then there's always state law. And sometimes I'm told, I don't live in one of those areas, but even there could be city ordinances and city rules about employment engagement. And I'm a Texas boy, and we've always been a right to work state, or free will, or whatever you want to call it. So it's been a little bit more open, I think, at the local level than some jurisdictions. But if that's an okay starting point, can you articulate some of the parameters that a business owner ought to be thinking about on how to line that up and get it right?
Well, you're exactly right. There's some industries and professions that are more highly regulated than others. And, that can impact employment relationships. Good example is OSHA. If you're manufacturing or you have high risk activities going on at your workplace, then the OSHA rules and regulations are going to impact your employees more than it would if you were maybe a retail establishment, that sort of thing. And there are a whole host of those. I think the one of most universal application are the wage and hour laws, because those apply to you. I think it applies to just about every employer, because just about every employer in 2023 is involved in interstate commerce. If you've got a phone, if you get deliveries from outside your state, you're in interstate commerce. And so you've got to pay the federal minimum wage, which is $7.25, and you have to pay 1.5 times the employer's regular rate for all hours they work over 40 in any given work week. And that sounds simple, but the regs on that statute are huge. And so it's not common sense. It's legislation and rules and regulations, all of which are creatures of politics and drafting. And so you've got to know what the law calls for. And if you guess wrong, it could be the penalty could be high. Let's say that you've got a misclassified employee, someone you think you're paying as an independent contractor, and you're paying just a flat rate to do a certain job for you. And it turns out that they're neither independent nor a contractor, and they're judged to be an employee. You could be on the hook for 1.5 times their regular rate for all hours worked over 40, plus double damages if it's deemed to be a willful violation, plus your adversary's attorney's fees. So that can really add up to be a big problem, particularly for a small employer. I've represented a number of restaurants that may employ 20 or 30 people, and they get the tip credit wrong, and all of a sudden they either owe the government, their employees, or their employee's lawyer 6 figures because they're able to go back 2 or 3 years and unscramble it. So it's that's one of those areas where if you guess wrong, it can be extremely devastating financially. And so you really need to make sure that you understand the exemptions. And that's one where, I encourage people to, pay an employment lawyer for a sit-down meeting where you go through those areas with her and have her give you a conservative opinion. And there's lots of ways to justify a legal determination that a particular job is exempt from overtime. But that if it sounds too good to be true, then it really may be too good to be true. And that's just an area where you may never get dinged, but when you do, it's going to hurt.
I recall back in the day, and I likewise date myself. I was a big fan of Perry Mason. I actually saw him, in the original release. So, not just the reruns, but there was a point in time where the basic classification between the so-called exempt and non-exempt relative to overtime was generally limited to people that were in a management position. They were considered exempt, and everybody else was non-exempt. And the non-exempt were the ones that did get the time and a half for the overtime. The exempt, if you're a manager working a 60-hour week, it was too bad, doodad. You had your salary package, whatever was agreed, and that was it. And yes, you might have had an upside for a bonus. But even some of that, what seemed pretty clear at the time, has changed materially between case law and modifications to those federal statutes. And that's why, to your graphic reference of the reg stack there, that's why I think that reg has gotten so compounded and involved. And so is there any notion of a basic delineation anymore, or is it all about job function and job description?
Well, it really is about, it's really both and. If you're paying somebody hourly, I don't care if they are your CEO. If you're paying them hourly, you owe them overtime. Full stop. So that's a pretty bright line. And one of the reasons why, the law really hasn't changed all that much, it's that our workplaces have changed dramatically. This was a Depression era statute when it was drafted in the 30s. And I have a colleague who says at that time, work was a place, not an activity. Now work is an activity, not necessarily a place. And it really contemplates, factory workers going in, clocking out, clear delineation between management and labor. And, now there's a lot of blurred lines. Some of them, I think, intentionally to try to get around this, this requirement. And, the regs have grown as the variations of the kind of work people engage in have grown. And, I think if you, it's like the independent contractor test. It can be very, very complicated, but I tell clients all the time, they say, is this employee an independent contractor? And I say, well, I'm going to ask you a very facetious question. Are they independent and are they a contractor? And, if you're honest with yourself on those 2 points, just about everybody can figure out who is and isn't an independent contractor. And I think this is unscientific, but I've just been doing this for 30 years. Probably 90% plus of the people walking around being called independent contractors are not. They're employees. They come to your place 40 plus hours a week. They don't work for anybody else. You tell them what to do and how to do it. Then they're an employee. And do you really, I always say, and this kind of goes in business across the board, it's more expensive to be right than it is to be wrong. And what I mean by that is if you've got a defense to a lawsuit and you want to defend yourself, we may end up, particularly in a wage and hour case, you may end up spending multiple amounts more to defend yourself than just to have paid it out at the beginning. And so I just tell everybody, you do what you want, be very, very conservative on this, because otherwise you're going to be sending one of my kids to college, or at least paying for their books one semester, because it gets really, really complicated, and it starts to bleed into other parts of your enterprise.
Right.
One person going to the Department of Labor can open up an investigation into every aspect of your business. If you've got 10 or 12 people, that's one thing. But if you've got 100, 120, 200 people with a lot of different job classifications, and this particular spotlight gets put on you, it can take a while to untangle, even if, like I say, even if you're clean.
Right. Let me ask you this. I'll call it common folklore, or there's a mentality that I frequently still to this day run into with small businesses. They say, well, none of that applies to me until I get to 50 employees. 50's the cut line. And as long as I stay under 50, I'm a lot more freewheeling in what I get to do. Is it a fact or fiction?
Not even close. Title VII of the Civil Rights Act applies if you have 15 or more employees. In Tennessee, it applies if you have 8 or more employees. So, the Fair Labor Standards Act, if you're in interstate commerce, if you have 1 employee, it applies to you. The Family Medical Leave Act, the Family Medical Leave Act applies if you have 25 employees. And then there's one that's 75. That may be, I always get these numbers confused. I don't have them memorized, but the highest is 75. Anybody with more than 25 employees, I always encourage to have either a fractional HR person or a full-time HR person.
Right.
Because once you have to start keeping track of leave and those sorts of things, you really need somebody full-time who's helping you with your benefits, helping you with compliance and that sort of thing.
Yeah. And the level of record keeping related to all of your handling of personnel matters really takes on a life of its own as well, right?
That's right. You want to make sure you're keeping good records, that you're documenting what you do. We can talk a little bit about documentation and how it can bite you if you're not careful. But you're going to want to know how you're treating people, because again, you get to 25, 30 employees and you get some turnover. The faintest ink is brighter than the sharpest memory, and you just forget what you've done. And then if you do something to one person and you do it differently for another, no matter what your motive was, it may look bad. So you want to make sure that you're being consistent and that you could, that you can document everything and as my grade school teacher would say, show your math, be able to show this is how we got here.
Yeah. I have a funny story I tell. It wasn't funny at the time by any means, but I ran a business and had gotten up to about 35 employees here in the state of Texas. And I had a lady that was working for me that was a chronic attendance problem. She could not get to work to save herself. And I put her on all kinds of warnings and programs and things. And I was documenting. I had a stack of stuff. But my wife and I owned the company, and we felt fairly benevolent. And we were not trying to be cruel dictators about anything. So the error on our ways, we let this string out way too long. And after I had a folder of about 40 instances of her tardiness and everything, I put her on a 3-strike notice. And I told her, we're going to start the clock now. You've had all these others, and I itemized them all. I said, I'm going to give you 3 more chances, and if you blow these, you're out. I'm going to have to let you go. Well, sure enough, it only took a week for her to burn through those 3 instances. So I gave her notice. Well, she ran to the State Workforce Commission and said I did an unfair termination. And I went through the whole appeal process, but they made me pay my state penalties for letting her go. And I thought, well, dang, but it wasn't cheap, but it wasn't expensive either. And I just took my medicine and tried to close the book on that. Well, several months later, I had another incident with an employee that I made a much shorter fuse on for my own good. And sure enough, they went to the state. And during the appeal process, which I filed my appeal as an employer, the agent from the state was telling this person, they said, now, Mr. Thorpe here has his rights as an employer. If you don't behave, if you don't meet the standard, he has a right to let you go, and there's no extra benefit you get because of that. As an example, if you had 40 absences, he could let you go, and there would be no penalty. And I thought, seriously, guys, you put my old case in your training now on how to coach these appellate reviewers. I thought, wow. So, I had the whole table turned on me right there in a moment. And I thought, oh man, this is nuts. So I don't know what the real takeaway on that was, other than I think the state was probably reviewing files and they probably told the first guy he was wrong in dinging me for what I had done, that it was way beyond reasonable what I had tried to do. But so now they put it in their training to make it a point of it. But I think my point in all that is, if you're a business owner and you get yourself crossways with an agency, whether it's state or federal, you may not know what you're going to get. And you better, really take the advice. And I like what you said about getting early counsel, put a plan together and document it. And the other thing I understand, Alan, is that once you do describe a plan, and if you can prove that is how your business practice operates time and time again, you have a much stronger defense as opposed to not having any of that.
I think that's absolutely right. And I think that decisiveness is important. And, I can see that breaking both ways, depending upon how, well documented the policy is and how well documented the leniency is. Because one way to look at the first anecdote is to say, well, you let this go for 40 times, it must not be that important. Why is timeliness now all that important? Well, if you've documented the fact that your benevolence, as you put it, and somehow you can show, look, we were trying to do everything we could. I think that inures to your benefit. If it looks like this came out of nowhere, all of a sudden now, whereas it'd been acceptable for 10 years or 10 weeks or whatever, now all of a sudden it's not. The natural human reaction is to say, well, why now all of a sudden? And I think a lot of employers, frankly, exacerbate their legal troubles by either being too nice, or by just not being decisive because they're worried about, getting sued. And sometimes you're just better off being decisive and doing it. And as you say, taking whatever medicine is there. I think the medicine is less when you can demonstrate that this thing is a non-negotiable. And
Right.
that goes to what you said about it being a good, here's our policy. Our policy says timeliness is very, very important. Maybe even the policy says why timeliness is important. Maybe it links back to one of your core values as a company. One of our core values is reliability. And if you're not here on time, that's unreliable. And when we hired you, we told you we wanted you to be reliable. Being able to tick and tie all of that together so that it doesn't look like there's something else going on, which is really what most jurors and judges are reacting to when, because very few cases these days of discrimination or even retaliation, no one comes out and says, look, here's why I'm fine. I know I've said this, but this is really why I'm doing it. And so it's really a circumstantial thing. And so if you look at the whole width and breadth, and whoever the fact finder is, whether it's an administrative judge or a jury or, an elected judge, and they look at it and say, well, okay, they've made it that, Acme has made it clear that timeliness is important to their operation, and it's been communicated to this person, and they were given 3 opportunities, and that's a different narrative than, well, they let it go for so long, and then all of a sudden they just came down on them without any real explanation. I'm not saying that's what happened in your circumstance, but that's what I see frequently.
Yeah.
Is like,
Yeah.
It's just built up over time, and all right, son of a gun, we're gonna bring the hammer down now. And if there are other allegations of wrongdoing that can undermine your legitimate business operation.
Yeah. This is where the idea of optics or smell test comes in. You, as an owner, you may have a good reason for doing what you did, but if you try to stand back and look at it objectively as an independent party, you can look at the optics of it, to your point, and say, well, he let her go for 40 times. My God, why now all of a sudden? And you kind of lose the sensitivity to I'm just tired of this. This can't be, can't keep going. We can't keep doing this. We tried. And so, yeah, I think the message here, guys, is the idea that think about it, create a policy, live by that policy. And in all my experience, I've come back to the point, I don't know who first taught me about it, but there's a mantra that says, we tend to hire too fast and fire too slow. So we make bad choices on the front end because we're quick to want to put a body in a seat. And then once we get that body, if they don't work out, we take way too long to exit them and start the process over again. And that script needs to get flipped all the way up 180 degrees the other direction. We need to be much more methodical and intentional about how we identify people to join our work teams. And then we need to have a protocol and a standard that we're going to assert that says, here's the expectation, here's how you can and might miss it. If these things happen, we're done. You're out.
And I think also, in addition to everything you just said, I think onboarding and training tends to be too short. Again, we're trying to get people on the line or whatever, bringing them in and really onboarding them and getting them aligned with our values, getting them aligned with our mission is very important. And then training them to do what you want them to do the way you want them to do it.
Right.
And, there are lots of people that if you ask them, well, what do you do for a living? They'll say, well, I'm an accountant. Okay. Well, are you an audit accounting? Are you a tax accountant? Are you a book? There are all kinds of variations there. And an experienced accountant has been trained to do things a certain way that may or may not be right, may or may not be aligned with how you want it done. And so unless you take the time on the front end to really go through your process, to go through what you expect the outcomes to be and how to get those outcomes, it's only going to be by the grace of God that you actually get an employee that does what you want them to do.
Yeah. A lot of my listeners now in the last couple of episodes have heard me refer to this, but there's a story that I was introduced to a plumbing company in Denver that is just hitting on all cylinders. They are doing things as a private business that I've never seen before anywhere in any industry. And to your point about onboarding and training, one of the things this guy does is no new plumber, I don't care if he's got a master license, he doesn't get a truck to go out on his own and represent the company without going through, checking off, and completing 18 months of training. And the training is not just about the technical side of how do you fix a leaky pipe, but it's customer service, it's policy and procedure, it's learning the system on how they book their deals and run their tickets and collect payments and do estimates. It's a full gamut of training that makes the company run well. Now, these people during that 18 months, they go out on ride-alongs. They're the second set of hands on jobs, but they don't get to have their own truck and their own dispatch until they've completed this 18-month program. And when those guys finally go out, there's several things that kick in. Number one, they get the freedom to run their own routes and get their own tickets. But with that, they get opportunity for extra commission and bonus for the things they do. But they've spent 18 months learning how the company wants it done. And this company has 5-star ratings out the wazoo. They're off the chart with customer satisfaction, callback, referral, all of those things that you would want in that kind of a business. And this is exclusively a residential plumbing company. They don't do any commercial. They don't do any construction. Mm-hmm. It's simply residential service. And it's a $10 million business. It's amazing.
Yeah, I think it's one of the shortcomings of American business, the way we recruit and employees, and then just throw them into the deep end and just expect or hope that they're going to do a good job. And when turnover is such a huge cost to a company, it's amazing to me that business owners and business leaders don't spend more time making sure that they're putting people in the right spot and giving them all the tools they need to succeed.
So, Alan, before we get off here, could you sum up for an owner who maybe has not paid enough attention to the whole employment game? Is there a short list of key considerations they ought to visit and explore to help get their house in the right order?
Yes. Mission is the first thing. You got to have a mission. And because you've got to have some common pole that you can point to every person in your organization that they can be aligned with. This is our mission. Our mission here at the Krohn Law Firm is to transform the American workplace one client at a time. And so when we hire people, we talk about that. And if you're not passionate about that mission, then it's probably not a good place to work for you. Go find some place where you're passionate about that mission. And then everything flows from that. So you want to make sure you understand when you add a position or you create a position, how does this position support the mission? What are the qualities that it's going to take? Write all this out. Write out a job description, not just of what tasks they're going to do, but who it all relates to, who they're accountable to. And then make sure that you really think long and hard about, okay, what is the unicorn that it's going to take to fill that role? And don't hire anybody until you reliably find somebody that at least looks and walks and sounds like the unicorn that you want. Now, that doesn't mean that you're going to get exactly what you want every time, but it's going to really increase the chances of that. And I think that one thing, being self-aware about what it takes to be successful, how the person fits into the mission and the company and what the values of the company are. If you're hiring to that, you're going to have a lot less turnover. And couple that with the training that you're talking about and, all this documentation we're talking about, make sure that it is not punitive in nature, but is proactive training in nature. In other words, I see people, we're going to give you a written warning. Well, if the content of that looks like you're trying to set the person up to fire them, that's going to have one set of reactions in the jury room. But if the whole context of all this document is clearly trying to train the person, correct a problem, as you said about the lady giving her every opportunity to succeed, then you're much less likely to be second guessed by a juror or someone down the road that your intentions weren't honorable. So that's always the first club out of my bag is spend time with your mission and spend time with your job descriptions. Make sure they're accurate, update them frequently, once a year at the very least, to make sure that if you were to read all of the job descriptions, that you would be getting an accurate picture of what's actually going on in your organization.
I love it. I always used to shudder when I would see managers that would try to write these job descriptions. They might put 3 bullets in it, and then the 4th one was other duties as assigned. And I used to cringe at that because it's like, no, when you read the original 3 bullets, they're not necessarily that comprehensive for what's really going on in the department. And that other duties as assigned, I've seen that getting chewed up in courtroom setting. It's like, yeah, no, that doesn't work.
In just about every legal aspect of employment law, the first document your adversary is going to want to see is that job description, and they are going to take it literally. And so it better be tight. Otherwise, you may have some painful hours in a deposition chair trying to justify what you've done based on what you've written.
Yeah, I get it. Well, Alan, we're about up on time here, my friend. Thank you so much for sitting in. I think this was really powerful and helpful. If people are interested in reaching out to you, what's the best way for them to do that?
Well, probably the best way is to Google me, Alan Crone, Crone, Attorney Memphis, and you'll get all kinds of information there. I also have a website, Krohn Law Firm, PLC.com, and I can be reached through that, and would love to help anybody avoid legal problems when it comes to employment law. I always say, let's eliminate that and let's just go make money.
I love it. Sounds good. Well, one last time, thank you for sitting with us, Alan. I really appreciate your time here today.
My pleasure. Enjoyed talking with you, Doug.
Yeah. Well, folks, with that, we are going to wrap this up. And I always like to remind people we've got a video version of this over on YouTube, channel by the same name, Leadership Powered by Common Sense. Hop over there, take a look at the archive, and look at all the other videos we've posted up there. And main thing, one way or the other, if you can get a hold of me, the best way to do that is go to my website, dougthorpe.com. That's THORPE. You can leave me a note, fill out the contact form, anything like that. If you've got a suggestion for a topic for the show or know someone who ought to be a guest, you'd like to make a referral, or heck, you might be a good guest for me, just let me know. Reach out and drop me a line. Look forward to seeing you then. For now, we're going to say goodbye, sign off, and go out there and make it a great day.
You've been listening to Leadership Powered by Common Sense, hosted by Doug Thorpe. If you would like to know more about the coaching and advisory services he provides, visit dougthorpe.com.